How do you report healthcare fraud if you are on a visa? A common fact pattern that our office encounters are individuals who work in the healthcare industry but are concerned about reporting fraud because they're worried that there may be consequences to their immigration status. Well, according to the statute that you invoke most of the time, which is the False Claims Act to report federal violations, which are Medicare fraud and Medicaid fraud, individuals are not allowed to be retaliated against for invoking their rights properly under that statute. That doesn't mean that the employer won't try to do something. So you need to think about what and how you'd be protected. Well, there's one way potentially to be protected, and that is to blow the whistle anonymously. Now, the False Claims Act doesn't provide squarely the ability to blow the whistle anonymously like other statutes like the AML whistleblower statute, SEC, and CFTC whistleblower statutes. Under the False Claims Act, you file a lawsuit in court secretively at first on behalf of the government with a whistleblower known as a relator. But to try to file it anonymously, you could do a technique known as a straw relator, which is get an individual who maybe doesn't have immigration consequences to blow the whistle and internally have a sharing agreement, or perhaps forming a corporation to blow the whistle. Now, both those strategies may have its own independent challenges. At the end of the day, it may result in a lesser whistleblower award, if any, if the case is successful. Typically, in a whistleblower case, by the way, if the government intervenes, the whistleblower is entitled to 15 to 25% of the proceeds. If it doesn't, 20 to 30% of the proceeds of the successful recovery. But the government may try to push it to the lower side of the scale if you're trying to be cloaked in anonymity at the end of the day. But it's important to work with an experienced law firm if you want to try to go through one of the quote-unquote anonymous routes. And at the end of the day, anonymity is not guaranteed at all. If the case proceeds, the government may find out who you are. Also the defendant, although it's more unlikely, potentially can find out who you are. So that takes us to the second track. What if you want to file the case to report healthcare fraud? And again, we're just talking about the False Claims Act now. We'll talk about other avenues as well. But if you want to do it using your real name and you have real-world immigration consequences. Well, the Department of Justice is the entity under the False Claims Act that evaluates the cases, works through the case with you, and also a different arm of the federal government is the one that might be able to give you a U visa or some sort of other protection for your status if the government feels your cooperation is that noteworthy. Now, as a whistleblower law firm, we do not give immigration advice. We always strongly encourage people to speak to immigration lawyers who focus their practice on this. But technically, this avenue is available. How it impacts your case in chief with the healthcare fraud under the False Claims Act is a question mark. Because if you're cooperating with the federal government in part to get a U visa, they may perceive that you're not cooperating for the sole motive, and it's accurate to some extent, to blow the whistle on the fraud and invoke the False Claims Act. And it may, again, negatively impact your relator/whistleblower share if the case is successful. Or they may deem that you're not entitled to anything because your motivation was exclusively for immigration purposes. And again, it's a delicate balance, and that's why you want to work through the issue with both an experienced False Claims Act attorney and an immigration attorney. You shouldn't be filing a False Claims Act case for the sole purpose of hoping that you'll obtain a U visa or other visa status. That's bad motives. The government will sniff that out and it will hurt you in the long term. But if it's incidental, if it's a byproduct of you blowing the whistle and potential retaliation, they might be able to assist with that process. Now, to give you some level of comfort, H-1B visas, I think last 2 years at a clip, the False Claims Act, the Federal False Claims Act, generally those cases take many, many years to work through, and they're worked through initially confidentially under seal. And what do I mean by that? In a normal lawsuit, after you file the lawsuit, the defendant gets a copy of the lawsuit and is on notice that they're being sued. Not with the False Claims. With the False Claims Act, the lawsuit is filed confidentially. It's not part of the public record. The defendant is not served. They do not know about the litigation, oftentimes for a minimum 2 to 3 years. It might be 5 to 10 years, depending upon what's going on with the investigation. So you have plenty of time in that interim most of the time to plan for your parachute, how you could softly land. Maybe there's other job opportunities out there that you can migrate to. I want you to take a second and think about the consequences of not reporting. It's a little different angle. Because yes, there are some consequences about reporting possibly to your visa, particularly if the employer wants to try to retaliate. But what if you don't report and the Department of Justice finds out about the misconduct and finds out that, number one, you participated in the misconduct, or even passively, number two, that you were aware of the misconduct for an extended period of time and did nothing? That also may adversely impact your visa. And I know you're thinking, oh my, damned if I do, damned if I don't. Well, when in doubt, there's something you could always do to speak with a whistleblower law firm to understand what your rights are. You shouldn't just passively sit with information that's damning to a company that you have, at the end of the day, may also hurt your argument to obtain lawful immigration status here in the United States. And when I say lawful, I'm assuming you have lawful status. If you don't have lawful status, there still are avenues to potentially report. So the key is, every year, hundreds of billions of dollars are defrauded from the federal government through Medicare fraud, Medicaid fraud, also defense contractor fraud, even though we're talking about healthcare fraud, TRICARE fraud. And a lot of individuals who are on visa status know about that fraud. Don't be afraid. Know that you have an avenue to report. And even if you don't want to report it to the federal government, at least you have an avenue to discuss it. Another thread I want to pick up on, healthcare fraud. Avenues to report healthcare fraud while you're on a visa. Well, some states, just a couple, Illinois and California, allow you to report private healthcare fraud. And they also have mechanisms that are anti-retaliation. But there's a little bit of asymmetry there, where before, under the Federal False Claims Act, you are working with the Department of Justice in your initial case. The DOJ may also be able to assist with the immigration. The state of California and the state of Illinois, they are not visa issuing entities, although they could potentially write something in concert with your immigration attorney if your information you provide is productive and results in some degree of recovery. So you should definitely know that. A lot of times, though, from experience, it's rare but not unheard of where entities and healthcare providers that are committing healthcare fraud, generally if they're defrauding one, they're defrauding both. So if they're defrauding the state of California, they're defrauding the federal government most of the time as well. Other states, you have to think long and hard, because let's say it's a state that does not have a statute. And when I say a state that doesn't have a statute, the Medicare program is federal. The Medicaid is a state program, but is also run through the federal government to some extent. So the Federal False Claims Act does cover that. But if it's private insurance in a state, and most of the states that don't cover it, your options may be severely limited. So to recap, if you are on a visa and you are aware of healthcare fraud, upcoding, 14-day rule, kickbacks, that's a big one. Kickbacks, paying for Medicare, Medicaid referrals, giving things above fair market value for Medicare, Medicaid referrals, and there's no end to the potential schemes that the schemers do. You do have rights if you have this information. Our whistleblower law firm, Brown LLC, has represented people who were on visas before and are presently doing it. But we do bifurcate the way we handle things. Since we focus on whistleblower cases, that's a portion of our practice, we would handle that for you, and we would strongly encourage you to work with your immigration attorney as well. but we'd also give you the timelines and I'd let you know that you have plenty of, generally you're going to have several years before something hits the pot. And what I mean by that, before the defendant finds out and you potentially have to suffer or endure retaliation. Also, we'd go over the architecture of filing, whether you want to file anonymously, the upside of it, further protections because your identity is cloaked to some extent. Downside for both of us, because when we take the case, we're on contingency agreement, is generally there's going to be a lesser relator share. So in short, if you have information, you really need to consult with a whistleblower law firm. Firm like Brown LLC, we have a track record of success in the space, although nothing's guaranteed. If you don't consult with an attorney, well, if the government comes knocking and think you're part of the problem, you may have a bigger problem than where you started off. So whatever you decide to do, take a step back, enjoy a free consultation with a firm like ours, if not with ours, with a law firm that focuses on protecting whistleblowers.